started. I should tell you that the community center wants us totally off premise or out of here by 9:15. We are going to try to reserve some time for questions and answers. We'll see how much time we have for that. We're more than happy to try to answer as many questions as we can. Naturally, people can come up to us as we're walking out. Tom's got to get on the road to Grand Rapids, and we do have to be out of this area definitely before 9:15. Okay, so we spend the first half covering the background information because it's very relevant to know that information in order to understand what these reforms are really all about. I guess the fundamental point we're trying to make is that you can't really understand and make any type of judgment on these reforms unless you know what the original law was all about. So with all those concepts in mind that we just went through, we're going to talk about these reforms. And this slide got a little misplaced here. I'm going to skip back over the cover slide in a second. But what do we have with these reforms? Well, let me just say, Tom talked about the number one legislative priority being no-fault reform. It was, and then we had Governor Whitmer indicating along the way that she was going to try to basically work with people, and she coined that phrase, doesn't want a solution that creates more problems than it solves. And we had a process where they were having some hearings about no-fault reform in general in the Senate Insurance Committee, and then there is the Select House Insurance Committee on reducing auto insurance rates, and they had hearings. But what happened in the end of May was all of a sudden the House and Senate just threw out their bills and voted on it with no public hearings. So they had hearings before the bills were introduced. You normally have hearings on the bills themselves so that we can review them, provide feedback, talk about ways they can be improved, errors and things like that. So they had the hearings first, then they put the bills out, no hearings on the actual bills, they voted on them, and then if you remember, they go to Governor Whitmer's desk and there's a showdown, and then a modified bill gets rolled out on May 25th, 2019, and it gets rolled out an hour before it's voted on, and I am at the Capitol. Tom couldn't be there that day. I was there actually with our father George. We're there at the Capitol. I was talking to legislators. None of them had actually read the new bill. It gets rolled out an hour before they vote on it, and they all vote on it without really having read it. And everyone's around the Capitol trying to read this thing, trying to figure out what it's all about. But yeah, they pass it, and then there's a signing ceremony on Mackinac Island, and everyone there is very proud of what they've done, even though they don't really understand what they've done, or at least many of them don't. That's my commentary, but in any event. And the law took effect officially on June 11, 2019. Again, no hearings on any of these bills, and basically no time to actually analyze them. So here we are, understanding the reforms. I think by covering the basic concepts we covered, we can try to blow through these a little quicker. So here we go. Not yet, but on July 1st, 2020, next summer, your insurance buying process is going to be fundamentally different than anything you can ever remember. The no-fault law has been around for 40 plus years. So over that time, you only had one option for no-fault. Now you got all these options. You got PIP choice options. You want choice? You got choice. You see, look at all these choices you got. You want some choice? Got choices. You got a $50,000 choice that might apply to you. You got a $250,000 choice that applies to anybody. $500,000 that applies to anybody. Lifetime, you can still do lifetime. You might get an attendant care rider now because you're going to be captive under these other policies. You might want to add some attendant care, but with some caveats about what's restricted there. And then you have these opt-outs. You have an opt-out capability if you fall into certain classes of people. Now, I'm going to try to cover these. The navigating the chaos summary that you all got, that is something that we wrote. We wrote it as trying to be academically neutral about the bill and trying to give it in terms of the straight point about the bill that we're making in each individual section. It might seem overly technical, but hopefully if you just read it, you can at least get the full scope of what each issue is all about, and I'm going to try to summarize it right now. So, first of all, people who buy these options, I'm going to talk about the $50,000 option in a second, in terms of how it's limited to a certain group of people. But this general rule applies. These are limits on the allowable expense benefit portion of the policy. If you remember Tom's presentation, he talked about the allowable expenses for life, and then you have work loss for 3 years, and the replacement services for 3 years, and if you die, you have the survivor's loss benefits for 3 years. Those 3 benefits aren't subject to these caps. It's just the allowable expense, medical expense benefit that is. And furthermore, these limits apply to each individual who claims benefits under the policy. So think in terms of a family. You got mom and dad, and they have 2 kids at home. They all have a limit up to that amount. If they're all in a crash, and they get the $250,000 option, they all have $250,000 per person. Okay? Now, real quick on this Medicaid option, this is only available to people who have Medicaid and who live with people who are covered either through Medicaid or have their own no-fault insurance. So if you're thinking about the people out there who are going to get Medicaid, the $50,000 Medicaid option, it's those people who are on Medicaid and or have people in their house either insured by Medicaid or with no-fault insurance. And I should say, though, that 25% of the Michigan population is on Medicaid. And so there's a lot of people who are going to have this type of policy. And to point out some of the problems here that we see with the reforms, at least from our point of view, is that you have all these people on Medicaid who are going to be able to buy the cheapest policy out there, the $50,000 policy, and guess what? Once they blow through that, who's paying for it? The government, right? So
Are you?
Yeah. Well, yes, you. Yes, I should say. I was affirming your call out there. Yes, you all are. As the people who support our government, we all are going to be flipping the bill for all those people. And with regard to $250,000, $500,000 options, those are available to anybody. But now getting into these opt-outs, here's this really weird thing that they created. And my take on it is that this is something that nobody really fully understood, or at least maybe only a select few people who drafted the bill. But this is how this works. So say Tom goes in to buy insurance on July 2nd, 2020, and he says, okay, I've thought this through. I want the $250,000 option. The law obligates the agent to then say, okay, Tom, you could pay this amount for the $250,000, but I'm going to offer you an exclusion to no-fault benefits, so that you can exclude yourself and your whole family from any no-fault coverage. The only thing you got to show me is that you have health insurance that covers auto accidents. The bill doesn't say how much health insurance. It doesn't say anything about if that health insurance lapses after the auto insurance, after an auto crash, what happens. It's an option for Tom at the forefront of the insurance buying decision to say, I don't want no fault at all. I have health insurance. And it's a complete and total opt-out. And our prediction is that there's going to be a whole bunch of people who choose this opt-out. And what they're going to find out is after they're in a crash, those that are in a crash, that they don't have any no-fault coverage. And when it comes down to the situation where maybe their disability from a crash results in them losing their job, losing their health care coverage, when that happens, no fault's not going to be there for them. And no fault's certainly not going to be there for them for the rehabilitation and care, long-term care expenses that are typically associated with a catastrophic motor vehicle accident. And I can tell you, for those who don't know about the health insurance coverage out there, we've got policies now, especially under the Affordable Care Act, that have pretty broad coverage, but they have some significant limitations on long-term care and rehab issues. So what you're going to find is that once we get going forward here, more and more people are going to opt out of no fault. This could have an effect on the cost of the lifetime option for those who want to stay in, because there'll be less people in the pool. So that's one way people can opt out. The other way is for people who are on Medicare. If you're on Medicare and you live by yourself, or you live with someone else who has Medicare or other health insurance that covers auto or no-fault insurance, you can opt out entirely of no-fault. And here's where I think the senior citizens got a bad deal here. I think a lot of this stuff is bad policy. I think a lot of it leads people to bad decisions. But here's where the senior citizens weren't given any good decision. And this is what I mean by this. The law says that these people who are Medicare, and like I said, who have other people in their house are insured, they can opt out of no fault entirely. meaning that if they're in a crash, what their experience is going to be, they get what Medicare covers, and that's it. The rest is on their own. Tom's going to talk about their rights in a tort case against the at-fault driver. But with these people, they have no-fault coverage. And their other choice, left over from the old law, was to buy no-fault, or is to buy no-fault coverage. But they aren't relieved from the predicament they had under the old law, which is this. Seniors had to buy uncoordinated no-fault. Remember I used the term coordinated, that's what it's called, to elevate your health insurance to pay first. Well, seniors could buy coordinated no-fault because Medicare can't coordinate with no-fault. So the gripe from the senior citizen class was, hey, we have to buy this uncoordinated coverage even though we have Medicare. Can you give us some option? And in that fair and affordable package that we talked about, there was an option there, and the same concept was being thrown out there in 2019 to allow seniors to buy a no-fault policy that would cover the amounts over and above what is covered by Medicare. So if they need long-term care, long-term rehab from an auto accident, they're going to get it through they're going to get what they can get through Medicare, and the rest is going to come from no-fault. That idea went nowhere. The seniors can either be out of no-fault completely, or they can buy that duplicative coverage that they were stuck with before. And that's where I think senior citizens really don't have a good option going forward. The one thing about coordinated coverage on these monetary limits, first of all, Medicaid can't coordinate. So those people are going to go to no fault first on first dollar. But the law, it being written in such a hasty fashion, or it wasn't reviewed by people who really knew what was going to happen here, the law doesn't provide any clarity about whether people can coordinate their PIP choice options. So you got this choice about whether you want to limit your no-fault coverage, and there's no real guidance to give consumers next year about whether they're going to get a $250 policy that's coordinated to allow their health insurance to pay first, and they got the $250 after that, or they just buy the $250 from no fault. The law doesn't say. And I know agents and people thinking about the insurance buying process are really perplexed by this, and there's just not any clarity in the law. The other thing that consumers are going to be presented with is this managed care option. And this is going to be allowed to be sold to anybody. And what it is, it allows insurance companies to create their own network of doctors that you have to treat with them. And you then treat with those doctors. And here's the thing. This is an example of how the law is filled with certain principles and concepts that are either ambiguous, that are poorly thought out, or that are even harmful. And here's where I think it might be even harmful. They allow insurance companies to create managed care networks where you have to treat with their doctors, and they add in a provision that says those people who choose this option cannot seek to have any other health and accident coverage pay for their auto accident until they exhaust their coverage to their managed care option. So you choose $250,000 of a managed care option, you get sent to the insurance company doctor, and guess what? They think you're fine, even though all the other doctors out there would say you're injured. And I'm being a little cynical here, but we can see this on the independent medical evaluation front, or the insurance medical evaluation front, where the doctors magically come to some conclusion that none of the treaters think. And so one would think that there are going to be instances where people in the managed care option are going to be treated by doctors who don't give them the care they need. And then there is this added restriction, this trap within the law that says you can't go access benefits you have through some other health coverage for your auto accident until you blow through that coverage. And guess what? You can't, because Dr. Cutoff says you can't get any more treatment. So, this is a real concern, and it's going to be allowed to be sold by any insurance company. They have to sell you or offer you a non-managed care option, but people are going to be offered a cheaper policy for the managed care option, and it's a real concern. All right. I'm not going to get into the details of these. I'm just going to say that these laws drastically reduce the amount that is going to be paid to medical providers, especially in the post-acute side. There's this Medicare aspect of the fee schedule where if you're providing services payable under Medicare, you get a certain percentage of what Medicare paid. But if you're not, then you get this limited amount of the charges you had as a provider in effect on January 1st, 2019. And the default rule for most providers is 55% of their charges. So the legislators passed a law that says that for an entire industry of post-acute care, they all have to get their rates slashed by 45%. And unless you're operating at some obscenely high margin where you're drumming up your charges, nobody can stay in business when they take a 45% haircut. And the post-acute side is free. And in this community, we have the likes of Origami Brain Injury Rehabilitation Center. We have Hope Network. We have multiple different therapists in this area. And wherever you go, when you have those types of businesses, they are freaked out and they will have to probably contract. And that's going to have an impact on communities. This fee schedule is so draconian that they really have an issue with how they can function going forward, especially if they treat a good number of auto patients. There's also this rule that if you are a neurological rehabilitation clinic, you need to be an accredited clinic to be paid. Here's the problem, though. In faulty legislation, or I should say vaguely worded legislation, they define this neurological rehabilitation clinic to be a person, and a person could be a company, it could be a human being, it could be an entity, basically anything, that provides brain and spinal cord injury care. And that's all it says. And so now the providers are also freaked out about that. We hear about transportation companies, physical therapists, anybody out there who's providing care to somebody who might have a brain or a spinal cord injury or both, thinking that they somehow have to become accredited by some organization that they normally didn't have to in order just to be paid under no fault. And if they're not, and a court would determine them to be required to be accredited, and they were not accredited, they get nothing. So they're freaked out. They got to spend money on looking into how they go about getting accredited if they can. And there's all this ambiguity. So this medical fee schedule is a huge issue. Then you have this other concept called utilization review. That is another way of saying government and the insurance companies are going to get together to determine what medically appropriate standards should apply to the payment of no-fault benefits. And the outline gives you some of the language that defines the scope of what really can be done here. But the Department of Insurance is going to work with insurance companies to come up with what standards should apply. And they're really going to determine it, on their own as they exist as their own independent associations that, on behalf of the government, on behalf of the insurance companies. You would think consulting with doctors, but the treaters are going to have to fight against these standards and somehow justify anything outside the standards. And they're certainly concerned about how that can affect the quality of care they can provide people. Attending care limitations. The other way of looking at this is an endorsement of what we call stranger care. And the reason why I say that is that this law changes the attending care benefit. Under the old law, as part of that reasonably necessary standard, if you could show as a family member you were caring for your seriously injured loved one and the doctor said so many hours were needed and you provided the care, you could be paid for it. You could choose not to work and be the care provider of the family. And you wouldn't have to have strangers come in your home from a commercial nursing agency and provide the care. Now what this law says is that, and this is what the law essentially says in a nutshell, it says that anybody who lives with the person and provides care, and anybody who had a prior business or a social relationship with the person, if you're in that class of persons, you can't provide more than 56 hours of care, or you can't be paid more than 56 hours of care. So we have clients who are concerned about whether this is going to apply to them. And by the way, the fee schedule and this limitation, the way the legislation is written, is not just intended to apply to people who are injured after the effective date of the statute. It's also intended to apply to those injured prior. And so there's going to be a huge legal fight about the application of this fee schedule and this attending care limitation on people already relying on benefits in the system. And so there's another aspect of the law, if you just take it to the bigger picture, where you're saying, why are we changing the law to make more chaos? Why are we changing the law to make it so that we have to fight over more? Why don't we just make the better decision to start with? Why was this necessary?
Is that 56 hours?
56 hours per week.
Per week, not 56 weeks per week.
Oh, good point. I'm sorry about that. Sorry about that. 56 hours of care. There's definitely a typo on that slide. We'll get that fixed. When it comes down to it, yes, it's 56 hours. In fact, I just saw an old client today. The mom takes care of the son. He's catastrophically brain injured. It's worked marvelously. He's made a great recovery and rehabilitation. He's still got serious impairments. But, they do it as a family, and they make it work. And they're really, really kind of freaked out about what's going to happen once these take effect, these limitations, which take effect on July 1st, 2021. That's the same thing with the fee schedule. The assigned claims plan, what time we got here? Okay, I'm going to try to get through this real quick. So, anybody who falls into the assigned claims plan, which I'll explain to you quickly here in a second, is capped at $250,000 now for medical expense coverage. Who are these people? Who are these people? So the law would allow somebody who was not insured under a specific insurance policy, if they were hurt, as long as they weren't disqualified in certain limited ways, but generally speaking, say a child whose parents didn't have auto insurance is playing in the street, and the child is hit by a car. That child's going to get benefits, but is going to come through the assigned claims facility, or the assigned claims plan, the ACP. And the way that works is that there is insurance companies that are members of the assigned claims plan, or part of the assigned claims plan, and a claim is submitted, and then it's assigned to one of the insurers, and they take over. And there are ways in which our insurance rates go to help fund the system so that we have people who are not uncovered. And so now, what the new rule is that for any of these people, as a general rule, for any of these people who were not insured under a policy, they are going to go to the assigned claims, and then they want to run into the $250,000 cap. So this is a way where children of uninsured parents are not going to be capped. People, pedestrians, people who choose to buy, get around by bicycle and don't want to buy auto insurance, and they're hit by a car. They used to have lifetime, now they got the 250 cap. So there's a huge, actually, if you total it all up, there's a significant number of people that fall in this category. And they all had lifetime care, this privately funded insurance system we had, and now it's limited, and the excess is going to be pursued most likely through us as taxpayers. Now, I'm going to, let's see here. Okay, sorry, just trying to make sure I know where I'm going here. All right, so with motorcyclists, here's where the motorcyclist has definitely an unfair result. So motorcyclists under the old law, when they're hit by a car, don't really question why, just accept this to be true. They would claim benefits from the vehicle that hit them. And even if they had their own no-fault insurance. So I'm on my motorcycle, Tom's driving his car, he hits me, I got Allstate insurance on my car, Tom's got State Farm, I'm claiming my no-fault benefits through State Farm, okay? That rule was not changed. But when these PIP choice policies begin to be sold next year, say I'm driving on the street, I still decide I'm getting my lifetime coverage. I got Allstate, I got my lifetime coverage. Here comes Tom, he's got State Farm, he's got the 250 policy. He hits me. I'm still drawing benefits from his policy, and I run into his cap even though I bought my own lifetime coverage. Okay? So motorcyclists, I was actually quoted by the Detroit News on this issue as saying that they're playing Russian roulette, which I believe they are when they're out there on a bike. There's not going to be any way for us to know other than getting the policy of the car involved, whether these people have lifetime coverage, $50,000 Medicaid coverage, $250,000 cap. It's all just a game of chance for them. There's actually a bill pending in the legislature to change this, but it hasn't gone anywhere. Same thing for employer-owned vehicles. Now we have this general rule that you turn to your own insurance company, but if you're in an employer-owned vehicle, the employee, and if they have their spouse in the vehicle or their resident relatives, they all, and they're injured in that vehicle, they all draw benefits from the employer. And that's just a unique aspect of the original law that wasn't changed by this law, but when the PIP choice policies begin to be sold, these people who are taking the corporate vehicle to dinner and got the family in the car, and they find out the corporation went the cheap route with the $250,000 policy, and the family's got lifetime coverage on their no-fault vehicle at home, they don't get to access that because the legislature didn't fix this. So this idea that people can choose their own destiny on the motorcyclist is not true, and on the employer-owned vehicle it's not true. And then now we have out-of-state residents. How many people have family that come in from out of states? Yeah. Well, what they had before is that for the most part, unless there is a limited situation that occurred, and I don't want to bore you with the details, generally speaking, these people would be able to access no-fault benefits if they were injured here in Michigan. And it would be for lifetime, and it would be something that they could, that they had. They didn't have to buy no-fault when they got into Michigan. It's just the way the system worked. Now, if you are an out-of-state resident, you are disqualified from no-fault benefits. That is a general rule. And the only thing that can save you is that if you are the actual owner of a vehicle that is registered and insured in Michigan. Otherwise, any out-of-state resident that steps foot in Michigan, any of your family members that comes here and is hit by some drunk driver at an intersection, they have no right to no-fault benefits at all. They used to have lifetime rights. So our families now who come to see us are in a definitely different situation. The transition to Tom, he's going to talk about tort recovery. These people have certain rights in tort, but we all have now different rights in tort. Tom's going to pick up on that.
All right. So I want to come back to the two hands for a second. Before we passed this bill a couple months ago, remember, if something was over here, you couldn't get it over here, right? And what was over here for everybody was medical expenses, therapy, and the like. It was not limited in dollars, which meant that over here, in the tort claim, those medical expenses couldn't be pursued. Otherwise stated, up until 3 months ago, if you caused an accident, you could never be liable for the victim's medical expenses because they were all over here. Never. That was the way the law was set up. What have you just heard? You've just heard that starting next summer, people are going to be able to go and buy these PIP guess policies. I'm calling them guess. I'm not calling them choice. Because they are a guess. You have no idea what's going to happen to you, when it's going to happen to you. But everybody has the right now to make the same guess. But what that means is that someone else's guess, if you cause an accident, becomes your debt. Let's go to next July. Somebody goes and buys a $250,000 no-fault guess policy. And we all live in a but for the grace of God go I world, and you make a mistake, and you cause a serious accident, and that person has a spinal cord injury. They're going to get $250,000 in no-fault benefits. And after they get to $250,001, guess who's paying? You. Because this hops from this hand now over to this hand. That's what happens. Think of the damages in an auto case as like air in a balloon. There's all this air in the balloon. And no matter how you look at the balloon, it's the same amount of air. If you squeeze one side of the balloon, the air doesn't just disappear, it just moves to another side of the balloon. So if we take away medical benefits out of this hand, they've got to go somewhere. And the first place they're going to go is to the tort liability hand. And if the person who caused the accident doesn't have any money to pay that debt, then it's going to go over to the third hand, which of course is what? It's the taxpayers. All right. This is what's happened in tort now. It's what we call excess economic loss. The idea that excess medical expense above the guess amount now can be recovered in a tort claim against the person who caused the accident. And you can't protect yourself from this. You cannot protect yourself from this problem other than making absolutely certain that you'll never cause a car crash. Because you could go out and buy lifetime no-fault to protect yourself, which you should do. You could buy lifetime medical to protect yourself and your family. But if you cause an accident and the victim purchased something less than lifetime, then you're on the hook for whatever is above their cap. And there's nothing you can do about that other than to buy as much liability insurance as you can afford to do, which you need to do within your means. You should buy as much liability insurance as you can afford, particularly starting next summer. You didn't used to have this debt, and now you do. So how did the legislature decide to deal with this? Well, they said, well, we're going to make everybody buy more liability coverage. Everyone now is going to have to buy at least $250,000 in liability coverage. Okay, that sounds like an improvement. However, then the statute goes on to say, but if you want to opt out, you can opt out and go down to as low as 50. All you have to do is sign a form. Here's the other thing. Remember when medical expenses were over here, we never had to fight over who's going to pay these, right? Because maybe you had to fight with your insurance company about whether they were going to pay for certain things, but you didn't have to have a lawsuit about who is at fault. You never had to litigate fault to get medical paid. Well, now you do. Once you're above the capped amount, now you do. And this is what's called a pure comparative fault system now. What's that mean? Well, it means that if you are the victim, let's say you didn't cause the accident, but let's say you're 20% at fault. Well, you can recover your medical expenses above your capped amount, but what you can recover has to be reduced by 20% because 20% of the fault is yours. Does that sound confusing? Yes, it's very confusing. It's very confusing. And how are you going to sort that out? Well, at the end of the day, if you can't agree with the other side, you're going to have to go and you have to try your case to a jury, because a jury is the one that decides how much fault goes to this person, how much fault goes to that person. But what it matters now is because that, what's called allocation of fault, now is going to apply to people's medical expenses in car crashes, and it never did until we changed the law this year. Okay, I'm going to cruise through a couple of things that are explained in your materials that I don't think are of as much importance to just the fundamentals of how this changes your insurance buying decisions. But I want to stop quickly here. Because this was the sell. The sell was your rates are going to come down. Right? Remember we talked about this thing metastasizing from Detroit now throughout the whole state? Well, the whole reason for it in Detroit was to bring down rates. So, are your rates going to go down? Well, what the insurers have been saying, don't take my word for it, is, yeah, maybe not. Because you're going to pay a little bit less for this hand, but you're going to have to pay more for this hand because it just jumped. It's not gone. It's the balloon, right? The air is still in the balloon. It's just moved around. The other problem is that the promise of rate reduction here is not to... Remember when in the beginning of this presentation we had that declarations page that was the total bill? You're not going to get a reduction on your total bill. You're not going to get a reduction on your collision coverage, the most expensive thing on the bill. You're only going to get a reduction on a portion of the bill called the no-fault benefits. And you're not going to get a reduction based on what you paid last year. You're going to get a reduction based on the average amount of that particular benefit sold by that insurance company. So while it was billed as a 20% reduction, 30% reduction, and people thought that that meant that next year's bill is going to be 20 to 30% less, it's not going to work out that way because it's not across the board and it's not a percentage reduction based on what you paid last year or the year before. The other sell in the bill was, well, remember these non-driving rating factors, which is such a confusing phrase. It sounds like someone who can't drive. But what it means is that people were being charged more for insurance based on things that had nothing to do with their ability to drive. So, were you married? Or were you divorced? Did you have a bad credit score? Did you live in a rough neighborhood? Right? That's how people were being really redlined out of insurance. And so, part of what was sold in this was, well, we've solved this problem. And it's true, there's some improvements. We have new provisions that didn't exist before. But in each improvement, there's a loophole. So the classic example is insurers can no longer base a premium on your credit score. Okay, that sounds good, right? But they can base a premium based on your credit data. Consumers can no longer be charged a premium based on their zip code. Sounds good, right? But you can be charged a premium based on your census tract data.
Or a territory.
Census territory data. So, what's the difference? Nothing, right? It's not a zip code, it's a census tract. It's not a credit score, it's the credit data that makes up the credit score. Okay, so we have about 10 minutes for questions, and this is really the question. And, I mean, obviously, look, do we have a bias here, right? We have an opinion? Of course, it's very transparent. There are people who agree with us, or are there smart people who disagree with us? Sure, right? But the question everybody has to ask themselves is, are we better off? Is this thing now, this two hands now, they're all like wrapped around each other, is this a better way to deal with the same place we started? Where did we start this whole conversation with? Car crashes. Car crashes have happened and they will happen. Harm from car crashes will result. How are we going to deal with that problem? You now heard